We do have a breaking news item we want to talk about this. The Supreme Court has ruled that Texas, their redistricting is now allowed.
You remember there was a big fight over Texas's mid-cycle redistricting map that normally they do it along with the lines of the census. When that comes out, they do a new map every 10 years. This would be mid-cycle, so about 5 years after the last census, where they put forward a proposed map. It got through their legislature and signed by the governor. Remember, those Democrats fled the state trying to stop there from being cloture so that they could vote on this. It eventually passed, and we have it now. Obviously, left group sued. This map would, in theory, could add as many as 5 seats to the House for Republicans based off the way the map is drawn. And the left sued. They got a district court to block the map. So effectively saying the current congressional districts that exist before the next vote are the ones that will remain in place. Texas appealed. The appeals court agreed with the lower court. However, the Supreme Court put out an order because there was an emergency application for a stay on that injunction placed by the lower court, basically asking the Supreme Court to stop the lower court from blocking their new map. And the Supreme Court went forward and said, yes, that Texas is likely to succeed on the merits of its claim that the district court committed at least 2 serious errors. First, the district court failed to honor the presumption of legislative good faith by constructing ambiguous, direct, and circumstantial evidence against the legislature. And second, the district court failed to draw a dispositive or nearly dispositive adverse inference against respondents, even though they did not produce a viable alternative map that met the state's avowedly partisan goals. So the Supreme Court has granted this stay, meaning they are allowing the use of this map for now. The lawsuit still exists at the district court, but at this point, it does not appear there would be time for the appeals process to be exhausted or even the merits of this case to go forward before the midterms next year. This is effectively allowing Texas's redistricting to go into effect and them to have elections in the midterms based off of that.
This is an injunction that stays in place through the appeal process all the way up to the U.S. Supreme Court. If the U.S. Supreme Court takes the case and ultimately issues a decision, that would be the end of the injunction. And if the Supreme Court does issue that, then that would, of course, they could go back, I guess, at that point. But this is a huge win for the redistricting, especially in these states that have come under scrutiny by the Supreme Court saying, no, listen, you look at this, you look at the census, this is not done in a racial way. I mean, that's really what they look at is, are you trying to put all Democrats into one district based off racial backgrounds and all Republican, and then kind of have these districts that have enough Republicans in it.
So what we see here is the Supreme Court, in an order, giving an explanation of why it's granting the stay.
Right.
But also naming errors that it sees by the district court. It doesn't necessarily have to do that in this case.
No, I think what they are saying, and we've seen this now and time again at the court as these cases have come forward, lower courts saying, no, you can't do this because they're kind of looking at the 1970s, post-civil rights movement. And this new court saying we are post-civil rights movement. And we can't keep asserting federal jurisdiction over how a state, based off their census, especially these growing states like Texas and others, and that's how it's based on the census when you add districts. So each 10 years you can either lose seats or gain seats, and we're going to start moving away from just looking at the racial factor. And then, of course, this is a job that is actually given to the states, in the Constitution. It's not the federal government's job to do it. It was put in place to fix the harms and the wrongs that were done when America was still racially segregated, Jim Crow laws. The list goes on to make sure that you weren't just shoving one group of people into a district and then, even though they were a significant part of the state, then they would have a diluted
rights.
impact in the Congress.
That's what Elena Kagan, Justice Kagan, in a dissent tries to argue, that this is, and that's what the lawsuit was about, because it came from the League of United Latin American Citizens. Right. They were trying to argue this is a race-based map.
Of course.
And what the Supreme Court is saying, no, actually, it's just a political map. It is partisan. It is aimed to give the Republicans an advantage because they are the party in charge. That's always the case when a legislature sets a map. Right. That's why some states have tried to move to an independent body trying to decipher it. Not like that has done much better in states like California. But when you look at what even Justice Alito, who writes a concurring opinion, says that the dissent doesn't even dispute that this is a purely partisan map, even though they're trying to say we shouldn't have granted this stay. But he goes on to say that it's the burden of the petitioner, the person who's suing against the map, to prove and untangle racial and political preferences.
Right.
And that's what the left is trying to always say. If you do a map that it favors the Republican Party, they always try to claim in their lawsuits that is a racist map. That is done for racial purposes. What the Supreme Court's arguing here is that there's nothing in the evidence that proves that this was drawn based off of race. It is drawn based off voting records and things of that nature, that you can't automatically assign racial bias based off of political bias. And that's a very important distinction here of why the Supreme Court decided to grant this stay on the errors that it saw in the lower court's decision of granting an injunction.
This is a big deal because what it allows then, it opens the door for other red states to be more creative in the way that they're putting together. And it doesn't mean you're going there to disenfranchise people intentionally. You can't do that. But what you can do is say, look, we have a really quickly developing state, especially in states that are adding seats, because like Texas is growing, Florida's growing, Tennessee is growing. So in census to census, you're going to have to add more congressional districts.
In the opinion, says the district court violated an established rule of the Supreme Court by improperly inserting itself into an active primary campaign, causing much confusion and upsetting the delicate federal-state balance in elections. So the fact that the court even blocked the map that the Republicans had put in Texas forward for their congressional map caused this confusion. But I think it's also a sign that probably, Jordan, the lawsuit in California will fail as well against California by putting it on their ballot and being able to get the approval of the people of California. There's a good chance that if the Supreme Court is kind of hands off here, that they will most likely be hands off there as well.
Yes, and I mean, I think that's the proper role of the court in most places. It doesn't mean that you're going to like every decision because remember, it impacts everyone, not just the red states. It used to be how the Civil Rights Act applied was to only a certain amount of states, and they had extra scrutiny in the southern states. Now that's been broadened out. So when they've always looked at this, but a big win for Texas. Yeah, does it mean it's so likely a win for California? Sure, but then the balance of power isn't totally upside down, if you know what I mean. So like California may be changing, but Texas is adding 5 Republican seats likely. So California isn't able to accomplish what they wanted to do, which was, outperform Texas.